This is Good Evening San Diego.
Good evening, San Diego. I'm Logan Burns.
And I'm Rafer Weigel. Thank you for joining us.
If you come down with COVID-19, California is ending the mandate for companies to pay for sick time off. For the past 2 years, California workplace regulators have tried to slow the spread of COVID-19 by requiring infected workers to stay home while also guaranteeing that they will be paid. But as of yesterday, OSHA has voted to end that rule at the start of next year. Companies will still be required to notify employees if they have been exposed, however, to the virus while at work. So joining us now to talk a little bit more about this, what this means for California workers, is employment attorney Annie Ellis. Annie, it's been a long time. How are you?
It has. Merry Christmas, Logan. I don't know if we're still allowed to say that, but I do.
I think we are. Happy holidays, Merry Christmas. Tell me what employees need to know as we lead up to January 1st with respect to getting COVID-19.
Well, what employees need to know is that if you want to get paid for being out for COVID and you don't want to dip into your other leave banks, then you need to get COVID before December 31st. But what business owners need to know is that starting January 1st, we are not going to have an extra 80 hours of labor cost per employee per year. So I think that, in spirit and in public policy, this was a good thing that we want to pay people, to stay out of the workplace when they miss work for COVID. But this is 3 years we've been dealing with this. 1 year at the federal level and 2 years at state. I think it's just time to be done.
Sure. So if an employee contracts COVID on December 31st and they tell their employer, how many days would they get off and still get paid?
So it's interesting under the state law, as long as you get it and file for it before the law expires on December 31st, you can still get your full bucket of 80 hours, assuming you haven't used any 80 hours yet this year. So you have a total entitlement of 80 hours for calendar year 2022. So that's just an interesting wrinkle that it can actually, stretch into January, provided that it started before January 1st.
So you say 80 hours. It's my understanding that you get 5 days, and then do you have to prove something in addition to that after you've taken the first 40 hours off?
Yeah, great question. So there's two buckets. There's 40 hours for a certain set of reasons, and then there's 40 hours for if you test positive. So if you are symptomatic and you test positive and you're a full-time employee, you're going to be entitled to the full 80 hours, but 40 of those, you'll probably need to provide a copy of your positive COVID test to your employer. You don't have to, but if they ask for it, you have to give it, and they are not required to pay you that second bucket of 40 hours unless you turn it over.
Is there some rule that, let's say somebody contracts the virus and they're out for the 5 days, the 40 hours, then when they come back to work, do they have to show either a negative test or do they have to wear a mask while at work? How does that all play into it?
So consistent throughout the pandemic, we have not been allowed to require negative tests as a condition of returning to work, but you can show a negative test to shorten your quarantine period. Now, some folks want to write out the quarantine period because they want to take advantage of this, free leave bucket, but some people don't have that much leave available to them. Maybe they already used it earlier in the year, and so that's going to be a way for you to shorten it. And then going into January, Cal OSHA has made some permanent workplace rules. We've had some temporary ones in place for the last couple years, and these are now going to be in effect for a minimum of 2 years going forward, and it's going to continue to regulate these issues. So there's going to be masking, there's going to be notifications, there's going to be outbreak procedures, but the biggest thing is exclusion pay is coming off the table. And what that means is if you get exposed to COVID at work, your employer no longer has to pay you for the time off related to that exposure. That was a separate right from the sick leave that we've been talking about. They were not allowed to charge against that big. And
I think another interesting thing about that exclusion pay is, did you have to prove that you got it at work? And if so, how difficult is that?
The burden was actually on the employer to show that it was not work related. And, it's one of those things, like, how are you ever really going to prove it? Contact tracing, and what you do is you go through an analysis of, have you had any close contacts on your personal level, so that it was a personal, transmission, versus, oh, wait, we've got 10 people that are next to your cubicle at work that have it. So yeah, it was probably work related. It was a little bit squishy of a standard, but I think most employers erred on just saying it was work related if the employee said so.
Was that the presumption that if somebody got COVID-19 and they worked, they got it at work as opposed to a party?
Yeah, early on in the pandemic, the governor actually passed a workers' comp law that said there is a presumption that if you've been in the workplace for a certain time period and then you get COVID, that it's up to the employer to show that it wasn't work-related.
One final question, Annie. If somebody gets COVID, do they have to show a certain test, or can it just be that at-home test?
The at-home test is okay. I know it's It's not that reliable. And we definitely have people doctoring photos or showing photos from April for an October request. But there's, going to be some follow-up to prove authenticity. But yep, the home tests are okay.
Okay. Annie Ellis, employment attorney. Good to see you, Annie. Merry Christmas.
Likewise.
If we don't talk to you soon, Happy New Year.
Happy New Year.